Well, good morning. Jagendra Rana here. So today we are discussing legal case studies of personal accident insurance. Legal case studies of personal accident insurance. So this is a case of Hyderabad Ombudsman Center. Case number 383. Srimati Nazmabi versus Oriental Insurance Company. The complainant was covered under personal accident policy for a sum insured of rupees 1 lakh for the period 5 April 2004 to 4th April 2005. So on 17 June 2004, a lineman of the electricity department requested the insured to climb on an electricity pole for repairs. During the process, they later suffered an electric shock and died. The insurer rejected the claim on the ground that there was breach of law with criminal intent. The complainant contended that her husband used to repair agricultural borewell motors. Now the insurer stated that the deceased had stated that he was an agricultural laborer in the proposal form. However, in the FIR it was mentioned that he was a private electrician. Moreover, he was not an employee of the electricity department. So the deceased was not authorized to conduct any repair work pertaining to electricity department, and therefore there was a breach of law. In the written submission of the complainant to this office, she stated that her husband was a motor pump repairer. Hence, there was no misrepresentation of the fact with fraudulent as alleged by the insurer. So one cannot expect an unlettered fellow to understand the nuances as regard the issue of breach of law. The issue is absurd. It is absurd that the judge acquitted the lineman who asked the deceased to climb on the pole for repairs. In small villages, it is known fact that the people offer to do odd jobs to earn small money. So criminal intent was not there either on the part of the lineman or on the part of the deceased. The insurer failed to explain how there was a breach of law, that too with criminal intent. So the insurers are directed to honor process and pay the claim of rupees 1 lakh without inconveniencing the complainant any further. This is a case related to the personal accident insurance. Another case of Hyderabad Ombudsman Center is 0369 Srimati T. Savitri versus United India Insurance. You know what happened in this case? The respondent company had an agreement with Indian Oil Corporation, according to which whoever purchased 10-20 liters of servo brand lubricant between 9/5/23 and 8/5/24, 2003 to 2004 would be entitled to free PA cover of rupees 50,000 and rupees 1 lakh respectively. Now the agreement also provided that an employee of the purchaser of the lubricant can be the person who is insured under this free scheme. So on 1st November 2003, one Sri Venkateshwara Rao purchased 20 liters of the said lubricant for his customer, Sri Jagannath truck owner. Now the invoice for the purchase was in the name of Sri Jagannath, but the certificate of insurance giving the free PA coverage was in the name of Sri Venkateshwara Rao. So Sri Venkateshwara Rao met with an accident on 11th June 2004 and later succumbed to them on 22nd June 2004. Now the insurer rejected the claim on the ground that the original cash memo for the purchase of the lubricant, which is mandatory, was not submitted. But the complainant stated that the original cash memo was handed over by the husband to the owner of the truck, in whose name the lubricant was purchased. So the insurer stated that there was no master servant or blood relationship between Sri Jagannath and Sri Venkateshwara Rao. The insurers furnished a copy of the agreement as well as the do's and don'ts given to the dealers and listing the procedure for issuing the certificate of insurance. So the insurers contend that the certificate of insurance is issued only with reference to a policy of insurance, and it is necessary that the condition of the policy be complied with for a valid claim to arise. Now it is clear that the primary intention of the scheme is to give insurance coverage to the buyers or employees of the buyers, dependent of the buyers of certain product of IOC. So the insurers contend that the deceased did not purchase the lubricant and the insurance under the scheme cannot apply to him. The deceased did not pay any amount either as the premium or otherwise either to the insurer or to the dealer of IOC. Thus he cannot be said to be a part of the scheme. So in view of the above argument of the insurer and wordings of the agreement between the insurers and IOC, the insurer's decision to repudiate the claim is upheld. Upon the insurer is upheld. So this is another case of PA. One more case of Hyderabad Ombudsman Center is number 0274. This is Mani Shekhar versus United India Insurance Company. This says that the respondent company had an agreement with Indian Oil Corporation according to which whoever purchased the 10-20 liters of Servo brand lubricant between 9/5/2003 and 8/5/2004 would be entitled to free PA cover of rupees 50,000 and 1 lakh. The same case of the same company. But the case is different here. The persons are different. The agreement also provided that an employee of the purchaser of the lubricant can be a person who is insured under this free scheme. So on 31st March 2004, the employer purchased Servo Pride 40 from Kirti and Company, who issued the insurance certificate with Mr. Chand Basha as the insured person and the employer as the nominee. So the insured person died in a road accident on 2nd April 2004. Now the claim was rejected on the ground that the certificate of insurance is not issued as per the terms and conditions of the policy. The document does not bear signature of the insured person and nomination is not valid and binding upon the insurer. So the employer gave indicting to the insurer that the claim money would be paid to the widow. The insurers furnished a copy of the agreement as well as the do's and don'ts given to the dealers and listing the procedure for issuing the certificate of insurance. Now it is clear that the primary intention of the scheme is to give insurance coverage to the buyers, employees of the buyers of certain products of IOC. Now the insurers did not dispute either the purchase of the lubricant on 31st March 2004 or the eligibility of the insured to be covered. So there is no doubt that there was valid coverage. The various objections raised by the insurers are procedural in nature and have no bearing on the validity of insurance cover. So the insurers are directed to settle the claim in favor of the legal heirs of the deceased as per law. Next case is of Ahmedabad Ombudsman Center. This case number is 225. Srimati Dakshaben R. Baghela versus New India Assurance Company. The complainant had a vehicular accident resulting into hospitalization and surgery which was not disputed. So the complainant claimed TTD, that is temporary total disablement for 202 days. Now while the respondent offered to settle the same for 51 days, it was observed that after 51 days from the date of accident, the complainant's employer directed her to join office for some emergency requirement and that she attended office for 10 days. Now, due to non-union of the fracture, she had to be hospitalized again and further operations were carried out. Thus, she was temporarily bedridden for another 71 days, after which she had again to join duties for 4 days on receiving an emergency call from her employer. So, the second operation could not unite the fracture, necessitating a third operation. She was incapacitated again now or another 95 days. So since the complainant did not join the duty but was recalled for some unavoidable purpose and since 3 successive operations had to be conducted for the same accident and since the respondent's own medical referee opined payment of temporary total disablement for the full period, the respondent was directed to pay temporary total disablement for all the days when she was incapacitated. So this is the judgment given by the Ombudsman, and these are the legal cases which were referred to the Insurance Ombudsman related to the personal accident insurance. Now say there are certain other cases of this nature which are decided by various courts. But before that, an important discussion has to be there on amendment to circular on payment of dues to policyholders and disclosures of unclaimed amount thereof. This is something very important because this was issued by the IRDA on 13th February 2014. The authority is in receipt of representation from various stakeholders, mainly from Life Insurance Council and General Insurance Council. Authority has examined the representations and following modifications are carried out to the above referred circular. This is a circular on payment of dues to policyholders and disclosures of unclaimed amount thereof. So the clause 3 is substituted with the following. All insurers are required to display the information about any unclaimed amount above rupees 1,000 of policyholders on their respective websites. A facility shall be given in the website of the insurer to enable policyholders or its dependent to find out whether any unclaimed amount due to them are lying with the insurer. So for this purpose, the policyholder may be allowed to enter the following fields in a window provided in the website for this purpose, that is policy number, PIN of the policyholder, name of the policyholder, and date of birth of the policyholder. The name of the policyholder and date of birth may be made as compulsory fields to enter, while policy number and PAN number may be optional fields. So based on the above information entered the insurer's website shall, if the credential match on matching of any two fields, confirm the name of the policyholder and address of the policyholder against whom any unclaimed amount is lying with the insurer. Initially, insurers are advised to uphold the information on the aforementioned formal as 31st December 2014 by 31st January 2015. Subsequently, the said information shall be updated on yearly basis. So as on 31st March and 30th September by 30th April and 31st October respectively. Now this unclaimed amount includes any amount payable to policyholder as death claim, maturity claim, survival benefit, premium due to refund, premium deposit not adjusted against premium, and indemnity claims, etc. remained unclaimed beyond 6 months from the due date for settlement of the claim amount. Clause 4 be substituted with the following clause. In case of any insurance policy, the insurer shall take all the required details of the bank account of the insured proposer in the proposal form. Insurer shall also insist necessary documents as a proof of the bank account to ensure authenticity of this information, such as cancelled check, etc. However, insurers are not required to collect the cancelled check where payments of premium is made by the proposer through check from its own bank account. So, retaining a copy of the check issued by the proposer shall be sufficient compliance of this clause. Now, the exemptions are the following are exempted from the applicability of the clause. All term insurance policies without return of the premium are exempted from the applicability of this clause. In the case of death claim, bank details of nominee shall be called for. In the event of a claim, all policies issued to policyholders having a bank account with a bank which is not having linked to RBI for core banking solutions, or all insurance policies where the annualized premium payable is up to ₹25,000 or such other sums as may be specified by the authority from time to time. So insurers shall also provide an option to the insured to change the bank account. A new clause 4C is inserted. All payment due to the insured relating to such policy will be routed through the said bank account through electric clearing system, national electronic fund transfer, real-time gross settlement, interbank, mobile payment service, etc. Thank you. Thank you very much.